Yes, you are highly welcome once again, Brighton Mtejichi, the barrister. This is the Legal Forum. Always we tell you to subscribe and set friends. And the reason why we do that is because we want to help each other. The content we know, we want to share it with friends. That is the essence why we do this. It helps the law school and the entire country at large. Brighton Mtejichi is my name. This is the Legal Forum, where we dive into law, any aspect of law, topics of law. Today we are in Evidence Law 1, and the topic of emphasis is opinion evidence. Now, what is opinion evidence? Before we go any further, let's first discuss or understand what we call an opinion. In real understanding, an opinion is any statement made by any person about his or her thinking over any alleged fact. Yes, the Evidence Act does not define what we call opinion, but however, opinion in legal meaning, it can be defined as the statement about what a person thinks about an alleged fact. So in this, it was well stated in the case of All States Life Insurance Company versus ANZ Banking Group Limited, and the court came out and defined what we call uh, an opinion. And court said that an opinion is an inference drawn from observed and communicable data. So that's how the court came out and defined what we call an opinion as an inference drawn from observed and communicable data. Now, what is an opinion evidence? What is opinion evidence? So, opinion evidence uh, is this is evidence. Opinion evidence is the evidence of what the witness thinks, believes, or infers in regards to facts as distinguished from personal knowledge of the facts themselves. Now, we first know that there must be facts, and you giving your opinion, you must rely on facts. Let's say if you're giving an opinion on accident, then the facts must be of accident, resgeste, facts that form part of the same transactions. Now, when you give out the statement, it must be infers, it must infer to the facts of the alleged fact. We are saying an accident happened. It happened like this and this and this and this. So for you, when you are giving out your statements, then there must be that clause, there must be that relationship between what you're saying and the alleged fact at hand. Let's move on. There is the general rule, and the general rule of opinion evidence is opinion of witnesses are not opinion of evidence is not admissible. Yes, the opinion evidence of witnesses at the existence of facts are not admissible. But at common law, witnesses can only testify about facts and no opinions. So at common law, when a witness is brought into court to witness, then at that particular time, he or she is not allowed to give opinion. That was seen in the case of Ara versus Lokef, that at common law, the witness is not allowed to give his or her opinion. He or she must give the opinion at basing must witness basing on a fact. What are the facts saying? That's how the witness must uh, surround himself. Now, as you know, the general rule always carry the exemptions. Now, the exemptions to the general rule, the instances where evidence can be admissible. Yes. Now, we have two categories: the opinion of expert and opinion of ordinary witnesses or non-expert. So, by now, we have to see section 43. Section 43 of Evidence Act says that experts' opinion can be admissible or can be admitted by court when the court has to form an opinion upon a point of foreign law. What does that mean? That when experts' opinion can be admitted by court when the court has to form an opinion upon a point of foreign law. So, which means now you have to understand that this means that a court can either reject or allow the opinion. By the time when the court is not satisfied with the opinion of the expert, then the court can easily reject. So that was seen in the case of Lawton, the case of Ara versus Turner. Yes, where Lord Lawton said that if on a proven fact, a judge can form their own conclusion without the help of the opinion. So, which means the opinion is unnecessary at this point. But we cannot rule out the opinion evidence because it is admissible. It is inadmissible, but sometimes can be admissible under the certain conditions, as we are going to see. Now, let's see expert evidence of expert, or the expert's evidence, expert's opinion. Who is an expert? An expert is that person who is professionally recognized and is able to perform his task basing on the professional conduct. See the case of Gathel versus Ara, where the court defined expert as all persons who practice business or profession which require them to possess a certain knowledge of the matter at hand. Now, when you are professionally in something, we presume that you possess certain knowledge over it. Either you are a teacher, you have knowledge of teaching. You are a lawyer, you have the knowledge over the law. You are a doctor, you have the knowledge over health issues. Whether you're a driver, then you have knowledge over driving. For now, we have to see what are the qualifications. What are the qualifications of an expert or someone to give expert opinion? What are the qualifications? You must hold. Now, we have competence. Competence means someone is able or someone is qualified. If I'm a doctor, then I must possess what we call certificate, show that I'm a doctor. Then that means I'm competent. The certificate will show that I went through school, I'm skilled over the same, and I can now do the work of health services in regards. We have the education background. Yes, the education background is supported by the certificate. Cause someone to have a certificate, then he must have passed through education or school. Then that is the background, the education background. Then it means that you have to hold. That's why you get the competence. Now there is what we call the level of expert. The level of expert. Uh, Take an example. In law, there is what we call senior counsel, junior counsel, advocate, and many more. So to obtain all those ranks, that's what we call the level of expert. The level of expert, the certain years you reach, it means that you are leveling up the expert you have. In driving, there is what we call license A, license class A, B, C, which means someone to move from one class to another. That is the level of expert or the level of competence. So let's look at what we call the non-expert witness. Who is a non-expert witness? This is the ordinary person, but giving his own view, basing on how he see. He is not qualified to a certain thing, is not like the doctor, the lawyer, and the whatever. But this person can give his own opinion basing on no qualification. Now, we look at section 45, section 48. Shows the certain kind of evidences given by non-experts. Now, we have what we call handwriting and signatures. We have customer. We have what we call the customs of rights or customs or rights. Now, we have the usage or tenets of anybody. Now, by explaining this, number one of handwriting and signatures. Now, for this, it means that a non-expert witness can come out and testify. Let's say you may find if it is the fraud case, someone wrote something, then here a non-expert who is not qualified anywhere can give that knowledge, telling the court that if someone writes or writes and we see whether is the one who wrote this or if the one who wrote this, yes, and we see, then it means that according to that witness, his evidence, if found true, his witness can be taken to be or can be admissible. Now, to the case of the customs or rights, you rarely see people in the village or in people still believes in the customs or culture where you find someone is not um, someone is not an expert or has experience in certain field. He can come out and say, you know what, when you do this, yes, when you do this, this will happen. When you say this, this will happen. These people are not qualified. They don't possess any of the education background, but to the extent that they can come out and speak out something which can at any time be uh, seen to be true, let's say in culture, then that person also can be, his statements can be admissible. Now, to the usage or tenant of anybody here, all these things are uh, lined on section 43, section 48. So when you read the Evidence Act, you will see the number of them well explained. For this, we have a scenario where someone used a certain language, a certain word to someone. So by the time he was taken to court, that the witness challenged and explained the meaning or the meaning of the word in their language, the real meaning of the word in their language, and they found out that the word means otherwise, and his evidence was admissible, or opinion was taken to was admissible. So that's it for today. Thank you for watching. Thank you for listening. Brighton Tradish is my name. Shalom, shalom. Stay blessed.